All right, so in this case, the state has filed a motion for continuance. Defense, are you in objection to the motion?
Yes, Your Honor.
All right, we're going to go on the record. Court is calling 2024 CR 010-307 State versus Johnny Joe Aguirre. Could I have parties announced for the record?
Galloway for the state.
Charles Gold from Segura.
And are you Mr. Aguirre?
Yes, ma'am.
All right, state, you filed a motion for continuance.
Basis for the motion is twofold. The first one is the complainant that is listed in the indictment pending against the defendant is unavailable for testimony. The state has made attempts to get in contact with this witness, and we believe he is necessary and material to prove our case beyond reasonable doubt. At this time, we've been unable to garner any meaningful contact with him. And then the second reason, I know we are set for jury trial, and in my analysis of the case, I saw that there were multiple gunshot residue swabs that were taken from multiple witnesses that were at the scene, and at this time we don't have those results. I did reach out to the lab yesterday and they have still not sent them to me. And so those are the two reasons for the motion.
Judge, I don't believe this is the first not ready. We've been here before on several cases with prior prosecutors. There's an MTR that was held as well. He's already been sentenced on that to 6 years. He's being held in the Broward County Jail until then. We're asking that this case is over a year old. I think that this case should be dismissed at this time, Judge.
All right, what is the cause number of the case that he's been sentenced on the motion to revoke? Sure. Do you know your cause number, sir, on that case? Do you-
I didn't represent him on that. Megan Cook
Okay.
represented him on that one. Enrique, I'm sorry, not Megan. Megan, that was
Okay.
wrong Megan.
2023.
Sorry, 50 what?
5468.
Yeah. Yeah, in fact, it was.
And counsel, I'm just waiting for Odyssey
And
to pull up the case.
And I just told me something else, that you held on a jurisdiction, you know, you sentenced them, and you're kind of waiting to see what's going on with this case as well,
Okay.
if I remember correctly.
My Odyssey, okay, here it is.
E-file's been down.
All right, so the court does note that on November 13, 2024, he was sentenced to 6 years in the prison. And the court did retain jurisdiction to see what the issue was with this case. All right, so with regards to the state's motion for continuance, the motion for continuance will be denied. What I can tell you, counsel and Mr. Aguirre, there are other cases that are ahead of you.
Mhm.
So if we get to your case, we'll see how the state proceeds. But the motion for continuance will be denied. All right. And so counsel, we'll have you back here at 1:30.
Okey-doke.
All right, thank you.
Thank you.
So Deputy Laura Aguirre is 1:30. All right, who's ready? All right, thank you. Jacob Anthony Davila. Court is calling 2018 CR 9921, State versus Jacob Anthony Davila. Could I have parties announced for the record for the state?
Opinion for the state of Texas.
Donald Wilson for the defense.
And are you Jacob Anthony Davila? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jacob Anthony Davila Jr. who was placed on deferred adjudication in 2018 CR 9921 for the offense of assault, impeding breath or circulation, family violence with a previous conviction on April 23rd, 2019 for a period of 4 years and extended for a total of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. Violation condition number 20. On or about the 14th day of March 2024 in Bear County, Texas, the defendant, Jacob Anthony Davila Jr., the then and there failed to comply with the rules and regulations of the Bear County Community Supervision and Corrections Department Intermediate Sanctions Program as set forth by the court, and that the defendant failed to comply with all conditions of probation and drug tests as directed, and violation of number 20.
How do you plead to that? True or not true?
State will waive remaining violation count.
Any objections
No, Your
to the
Honor.
waivers? Did you understand by pleading true to violation of condition number 20, the court could find it true, grant the motion, find you guilty, sentence you to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 20?
Yes, ma'am.
Court will find violation of condition number 22 true. Is there a proposed agreement?
There is, Your Honor, that is to revoke the defendant's probation, you keep the defendant guilty and sentence the defendant to 3 years TDC.
All right. What has he done on probation?
Judge, he's completed the BIP. He's completed ISF.
Yes. He did complete outpatient.
Any objection to the court reviewing the probation court summary?
No, Your Honor.
All right. So why isn't he following through with drug testing?
Judge, what has transpired, as I understand it, is in July of 23, there was an amendment made and Mr. Davila was placed on GPS. And it's my understanding that at that time, when they were fitting him with the monitor, he was asked where he was going to live, and he told them where he was going to live, which included living with his wife and kids. And he was placed on the monitor and was living with the wife and kids. Then in December of 23, the probation officer changed, or somewhere around there. And at that point, they said, hey, wait a minute, you're not supposed to be living with your wife, and started giving him a hard time. And then as it progressed, told him that they were filing the motion to revoke his probation, and things dominoed from there. He was working, he was doing all the other things, but not being able to be with his wife and kids led him to go astray. And there was never a GPS violation. There was, whether it wasn't caught, there was some error along the way. But that was his basis for not doing it, not because he was doing drugs or anything like that.
Well, I mean, I don't know if you were doing drugs or not because you didn't test.
Remember when we had a talk and you put me on the gang unit? That's when everything went downhill with the gang unit officer. The first probation officer was going good. The gang unit officer told me I had no contact right. Since I got out of the county jail, I was living there. And then he basically told me he was in the NT Army for no contact. But the GPS monitor, I was living there already for 6 months. I was already living there.
But we're not here for that. What we're here for is you're not doing UAs. So I don't understand why you're not doing that.
I was doing everything until 6 months, they gave me a different probation officer, which was the county unit, so when everything went haywire from there.
All right, is there anything else? And probation? Did he? Other than the drug testing, did he complete everything?
Like I would have to check and review the file as far as the over support meetings and deferred. There is a total outstanding balance on the account.
Did you complete your sober support meetings?
Yes, ma'am.
Did you turn those in? That's either yes or no.
No.
All right. So here's the problem. When you don't,
Any meetings?
yes.
Yes,
Did you turn them in?
I have to pay.
So here's the problem. When you don't turn anything in, nobody knows that you've done that. That's the problem. All right, this is what the court is going to do. The court is finding violation of condition number 20 true. Court is going to grant the motion, find you guilty. There's an affirmative finding of family violence. Court will sentence you to 4 years in the prison. The court will request the therapeutic community. The court will give you credit for any time served. Did you review? Just 1 moment. Probation,
Ma'am?
was there any, I don't see a no contact order with Sandy Davila.
Yes, Judge.
Was there a no contact order?
Yes, Judge. Originally, it was a no harmful or injurious contact, and then that was changed to no contact.
All right, there's to be no contact with Sandy Davila. No unsupervised contact with minors. And no residing with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that means, you'll need to speak to an attorney. Do you understand?
so after the 4 years, I can talk to Sandy.
It's best that you do not, and I'm ordering no contact.
Can like do a divorce or something? We just had a baby.
Well, that's something that you'll have to discuss with an attorney.
All right.
Your problem is that you have this assault choking, and the reason why it's a second-degree felony as opposed to a third-degree felony is because you have a prior family violence case. So you're going to need to work on you before you're in any type of relationship
Yes.
and figure out why you get angry with people, what's going on with you. Because children in households, they don't need that because they're trying to learn and they want to be in a household that is serene and pleasant, okay?
Since 2018, I haven't caught another case in good for 7 years.
I mean, I appreciate that, but this is what I want you to ask yourself. Look at your attorney. Has he ever been on probation?
No.
Has he ever caught a case? So you still need to work on yourself. All right? Because, and your attorney did a very good job for you because you were looking at 20 years. You understand?
Yes, ma'am.
All right, good luck to you.
Yes, ma'am.
All right, anyone else ready?
Yes, ma'am. Please wait. Sit down, please.
Willie Contreras,
Just like house. It's good.
Judge, I think the state is still waiting on a criminal history report.
I
Before
didn't
they
think
could
the
make-
was to wait on his bond, so I wanted to get his criminal history.
Okay.
report. And I'm just waiting for that from my investigator.
all right, thank
Your
you. Anyone else ready?
Yes, ma'am. It would be, Samuel Bach, page 8, 4 down. For restitution.
Bach.
Thank you.
Good morning.
Good morning. All right, so in this case, we're here for restitution. Are
Yes.
y'all prepared?
Well, we were just served with discovery, and so on that, no, because they're asking for restitution, which we had no notice of until today, about, I don't know, an hour ago.
All right, so State, do you have any witnesses for the restitution hearing?
I did hear, and disregarding the document that she was served, I served them on her. I received it this morning and I served them on her as she appeared.
All right, so do you have any objection to their witnesses appearing by Zoom for the restitution hearing?
Yes, I do, because the lack of, so we filed a 3914 on in February of 2024. And to our knowledge, there was no restitution at this point. We don't have the ability, we know that he was paid 30,000 in restitution from a insurance claim out of the insurance that covered the car that my client was driving. And so we don't have those documents. So at this point, we would let the court know that we can't proceed if they're claiming they're still entitled to restitution, even though they've been paid 30,000.
All right, so this is what are your witnesses going to be available at another date or no? All right, if you want to talk to them and see if they're available to testify at another date, if they're not available, I'll take their testimony, and then if they need to be recalled, they can be recalled.
Okay.
And I got your ex parte
There's
request. So what I have to do is I send that to, it'll be sent under seal to the voucher committee. They'll look at it, and they're very quick about a quick turnaround, and then I can sign off on it.
Okay.
All right.
Judge, he's not available to testify today.
All right, I'll take testimony today, and then if they need to be recalled, they can be recalled.
Great. And then, Your Honor, we do have two other issues that we'd like to address today too, just to put on your radar. And that is
To reconsider.
motion to reconsider. And then the second one is that conditions of probation were amended yesterday without notice to the defendant. I think there was a report that was sent to the court that had to do, and it's not necessarily we're objecting to it, but we've not seen it. And he was ordered out, dual diagnosis outpatient, AANA. We haven't seen any of that documentation. I talked to your court liaison and she said that she can give us copies of it to review. But you'd have to authorize that.
All right, so I had ordered a TAP and MIC evaluation in custody. So are these the results of the TAP and MIC?
That is the TAP evaluation came back with dual diagnosis outpatient program. A supplemental report was submitted to the court yesterday or day before yesterday, and it said for those conditions to be amended. Those conditions have not been amended just yet.
Okay.
But it is for dual diagnosis outpatient program, sober support meetings documented, and monthly UAs.
Okay. All right, and can you let her view the report, the recommendation, the TAP recommendation?
Judge, I need clear direction. Then you, are you saying give her a copy of it? Or are you saying let her see it?
She can have a copy of it, but it's not to leave the courtroom.
I'll return it upon after review.
Can you forward that to the voucher committee? All right, court is calling 2023 CR 8868 State versus Samuel Allen Bach. Could I have parties announced for the record?
Megan Gallagher for the state.
Jody Sawyers for the defense, along with Samuel Bach.
And are you Mr. Bach? All right, so Mr. Bach, the deputy will tell you to stand there. We're here for a restitution hearing and also motion to reconsider conditions of probation. So we'll start with the restitution hearing first. State, do you have witnesses?
Yes, Your Honor. State Claus Crows, D'Amicus Jr.
All right, let's talk about that. Judge Boyd had quit the lineup in this session, starting with Johnny Joe Aguirre's case. The state wanted a continuance, arguing they couldn't get hold of a key witness, and were still waiting on labor salts for gunshot residues. Wobb's defense objected, noting the case was already air-rolled. Aguirre had already been sentenced on a motion to revoke to 6 years, and the court had retained jurisdiction. Judge Boyd denied the continuance plainly, but reminded counsel that other trials were ahead on the docket. So if his case was reached, the state would have to be ready. It was a firm call that kept the calendar moving without dragging things out. Jacob Anthony Davila, who had been on deferred adjudication since 2090 for family violence, by impeding breath with a prior conviction, had admitted to violating probation by skipping drug tests. The defense explained he had actually been living with his wife in Kinder Jeps for 6 months, until a probation officer changes, suddenly flagged that as a violation, the situation spiraled from the red defense argued he had been working and generally compliant, but a misjudgment sealed it. Judge Boyd pointed out the obvious that without documentation, Noon could know if he was attending support meeting. She revoked probation, found a family violence affirmative, and sentenced him to 4 years in prison with credit for time served. And at therapeutic community recommendation, she emphasized that Davila needed to work on himself before being in a relationship again, while also crediting his attorney for negotiating him down from a possible 20 years. The message was sharp: you were given chances in need. Tune your behavior. Finally, Bakken for restitution hearing this one turned into a procedural skirmish defense, complained they had not noticed restitution was even in play until an hour before it, and argued the alleged victim had already been paid $30,000 by insurance. The state scrambled with witnesses appearing by Zoom and last-minute documents. Judge Boyd allowed testimony but left the door open to call witnesses if needed. She also clarified probation amendments, died to tap in mice valuations, noting a dual diagnosis outpatient recommendation with sober support meetings. It was defense was allowed to review their report in court but not take it out again. It was careful courtroom management, balancing fairness to defense while making sure treatment recommendations were enforced. The overall tone of was brisk and no-nonsense. Aguirre's continuance denial showed the court's commitment to efficiency. Davila's sentencing highlighted accountability, mixed with an opening for rehabilitation, and box hearing showcased judges' procedural control when surprises land on the table throw. Acquittal Judge Boyd stayed steady, never sensational, sometimes wry, but always deliberate. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I urge everyone